Hello. I am very fortunate and very privileged to mention that we have a guest this morning here, Ed Beshara, who is a prominent immigration attorney specializing, among other things, in EB-5. And we're going to have a dialogue with Ed. We're going to cover what immigration attorneys and what broker dealers can do together to help our clients, the EB-5 investors. With that, Ed, would you like to tell us a little bit about yourself?
Sure, Marco. Well, thank you very much for the invitation. I'm honored to be able to share this video conference because I know that you are very well known and well established and have a great reputation. So thank you, Marco, for inviting me. But I've been an attorney now for 45 years. The early part of those years was in Australia, where I was born and from, and went to law school there. So I was a lawyer, barrister, solicitor, admitted to the bar there. And then when I came to the US, they said, you have to do it again. So I went back to law school, started in January of 1980, and I was admitted to the Florida bar and have been practicing US business immigration and family immigration in Florida, which allowed me to represent clients throughout the US, but I've been doing that since 1983. So I've been a US business immigration attorney for 40 years, well, really 42 years. And then I've been doing EB-5 when it started, and I started doing EB-5 back in 1992. I've really saw a variety of clients, whether they wanted to invest in their own projects or invest in other people's projects. Over the years, we've seen all different types of scenarios, and hopefully we'll be able to talk about those different scenarios today, Marco, and share our experiences.
Thank you. Thank you so much. So, along those years, and especially obviously now, what kind of risks in the immigration have you been seeing that the investors could stumble on or should be careful about? What kind of, let's start from there, what advices you can give our investors?
Right, because the investors could be two types. The investors under EB-5, employment-based category 5, they can be involved, for example, in a direct EB-5 investment, which means that they could invest their money in their own US business and run it, manage it, put the money into it. Or alternatively, they could invest their money into an EB-5 regional center business, which is basically managed by a developer, a different company. They invest their money and technically they walk away. They may have a little bit of a management role. They still need to know what's going on. But one is more active, direct, and maybe one is more passive, EB-5 regional center. But I think that the best advice we can give is that when an EB-5 investor, a foreign national, says they want to invest in a business, is that the immigration aspects, which we advise on as the Immigration Council, will say, the project has to show certain documents to allow them to be an EB-5 investor, which is under the immigration regulations, rules, and policies. And then they move forward, they file their petition, they may get the conditional green card, and they may get the full green card. But that's from an immigration lawyer standpoint. We're talking about immigration processes and procedures to get a green card. But because they're making a required investment of either 800,000 or $1,050,000, they have to also make an investment decision, a business decision. And an investment decision is coming from themselves or coming from the help of you, Marco, right? Which means that not only do we have to combine now an immigration path, but also an investment path. I can only advise on the immigration, And therefore, they need guidance to invest either in their own business or a regional center business, but they need guidance and advice from an investment advisor, and that's you, Marko. So hand in hand, we need to work together on that, because if the investor goes directly to an EB-5 regional center project, I can represent them, offer immigration advice, but they're going to be on their own. Listen to what the regional center says about the viability of the project from a financial standpoint, return of capital, but they need not to be on their own. They need guidance. And that's what I see that's missing right now, is that they need more guidance from investment advisors and like yourself, Mark.
Thank you so much. On that topic, actually, I have written an article that was published last year in IIUSA, why immigration attorneys should consider EB-5, but at the same time, be working with EB-5 brokers regulated by FINRA SEC for the exact reasons that you mentioned, for the type of um, um, help that assistance that we give them. How about when they decide? I get this question all the time. Why do I want to? I don't want to give my money to a third-party regional center. I want to, keep the money in my pocket, and I want to be able to invest in a direct EB-5. Obviously, for people who are already in the United States and who know the ins and outs of how to run a business and have plenty of money to invest, that might be the appropriate thing. But what do you see, that could be an issue with some of the foreigners, who want to do this plunge to open up a practice here, direct investment? What would you say, Ed?
Yeah. We, of course, over the years, we've represented many foreign nationals wanting to come in to invest in their own business. And whether it's what we call an E2 visa, where they are a citizen of a country that has a treaty with the US, they invest maybe a small amount in running their business, or they want to do an intra-company transfer. They have a company in their own country, and they want to create a subsidiary of that parent company in the US. And then of course, you've got the EB-5 regional center projects that basically are accepting investors' money and then running with the management and the process. I think that, over the years, and this has not changed, is that foreign nationals who have made money in their own business or they've done very well, the reality is that even though they're successful in their own country, and they preserve their wealth, it doesn't mean coming to the US and putting money in their own business or investing in the US is the same as if they were in their own country. They have to realize that the US is different. The US has different rules, different policies, different way of doing business. So just because a foreign national investor is successful in their own country, it doesn't mean to say that they're going to be successful in the US unless they get guidance, business advice, investment advice, immigration advice. They need to bring in a team of professionals to preserve their wealth and to make sure that they're on the right path. And this is the American way of doing things. So to answer your question, I think that most foreign investors coming in, if they want a quick path to getting permanent residency, if they want to not have the headaches of learning the new ways of doing business, well, then investing in an EB-5 regional center project is the easiest and least costly way, right? And then getting that direction and advice from me as the immigration attorney and from you, Marko, as the investment advisor and broker-dealer is a way to go. If they ultimately say, look, we want to invest in our own business, that's the decision they're making. But they still need to get the whole team of professionals to advise them. But it's going to cost them more to put money in their own business, because then now they have to create 10 full-time jobs. They have to create the infrastructure to allow 10 full-time jobs, and they have to worry about overhead, management, lease arrangements, buying a business, property, etc. And the cost factors are 100% more than if they were investing in an EB-5 regional center project.
I can't agree with you more. This is exactly the issue. With a foreign from a developing country or wherever, where the labor costs are so much cheaper than the United States, they believe that with the 800,000, even with 1,050,000, they'll be able to, create those 10 jobs,
Yeah.
full-time jobs, the W-2 jobs for 2 years, and yet be able to at the same time make money. So those two things, there's an underestimation, I think, as to how difficult they are. So
Sure.
if a investor is, talking about not 800, but, multiples of that, and if they're not trying to squeeze themselves to create the 10 jobs, they need to create the 10 jobs to be able to do the business they want to do here. And the immigration benefit, comes as with it. So in
Right.
those cases, we definitely, go along with the idea that the direct is good. But for most, and the statistics show it, when you look at the USCIS publishes, a yearly basis, how many direct, how many regional center. I mean, the numbers speak of themselves, over 90%,
Yeah.
I believe, is all regional center.
Mm.
Moving to the actual application on the immigration, what are the common legal pitfalls that you see, whether it's at the 526 stage or the 829 stage? What has been sort of your experience for people underestimating or making some mistakes?
Well, I think that, from an immigration standpoint, not
Yes.
from the investment
No,
standpoint,
which,
because remember, when they make the investment in their own project or an EB-5 regional center project, the investment has to be 100% at risk. These are the legal rules. 100% at risk. There cannot be any redemption. In other words, guarantees from the project that there will be a return of their investment amount. There can be mechanisms in place for return of capital, right? But you've got the return of capital, investment amount, money being committed at risk. That is an investment decision they're making, but that's part of the immigration rules as well, right? So the immigration rules is dictating the way that they can get a return of capital, right? Even though the investment's at risk, no guarantee for the return of that money, but mechanisms in place for the return of capital through, let's say, a loan repayment if it's under a loan model for an EB-5 regional center. But to answer your question, if someone is filing an immigrant petition, which is a 526 petition, right? We know that we need the documents from, let's say, the EB-5 regional center project. We need to show that the EB-5 regional center project has filed a petition, 956F, which is including the offering documents, economic report, business plan, fund administration. All that is submitted to immigration. Once we get a receipt notice, then the investor can file their 526E petition under the EB-5 regional center scenario. But also, as far as pitfalls, now they have to show where do they get the money from to invest, authentication of source of funds, the path of funds. Now, that is a process which we've done many times, and the client can show where the money came from, either through different sources or through a gift, as an example, right? So the person making the gift, we have to show where did they get the money from. Money coming from certain countries that have currency restrictions about money coming out. How did they get the money out? Or how did they get the money from another source outside their country? So the authentication of source of funds and path of funds is part of an EB-5 petition. On the average, whether it's 800,000 or 1,050,000, we're accumulating on the average 10,000 pages. 10,000 pages. That's a lot of pages to back up the source of funds, to back up the transfer and path of funds. When we file it, no matter how good we think the package is, and the government should be applying a preponderance of evidence test, and that's the lowest test, preponderance of evidence. If you have 10 documents and 6 are correct, well, that's preponderance. If you have a test that says you have to show beyond all reasonable doubt, and if you supply 10 documents, our government has to accept 10 documents. Clear and convincing evidence test is that if you supply 10 documents, they want to see 8 documents are true and correct, in their opinion. So even though the test is preponderance, the government is applying a higher standard. They're saying, we want more information, more documents. They send out what's called an RFE, request for further evidence, on source of funds. And we know that the source of funds request, RFE request, is made up of not only facts that they want to see clarification of as far as source of funds, but they're also including what we consider to be template requests. Template means that they have a book, and if they want to request certain information about a certain aspect of source of funds, they take the language and put it in the RFE for the particular client. So the RFE language from a template could be applied to many investors, right? So you've got template language in the RFE as well as actual reference to the facts of a particular case. And that's common. Do we agree with these RFEs? No. A lot of the RFEs from our standpoint, and maybe from your Marko's standpoint, are unfounded.
Spurious.
Right, unfounded. And unfortunately, if we go back and say, you're not applying the test properly, preponderance of evidence, you're wrong, we're saying that to an adjudicator that is making ultimately the final decision. So diplomatically, we have to be very careful. We respond diplomatically to the RFE. We respond. We supply extra information, documentation, more of an explanation, and then we move on from there. So we're playing the game. It's a game that has rules, and we're playing that game, right, regarding source of funds. So most of the RFEs, request for further evidence on a 526 filing, most of the time is on source of funds.
Right.
Very rare, if they are going with a good project, a viable EB-5 regional centre project, it's very rare that at the 526 stage, the government's going to be asking questions on the viability of the EB-5 project.
100%. I've had it in project related, which were really spurious, like back in the day when TEA had to
Right.
be, certified, and we would send the 2017 one, and it would be 2018 or 2019. So
Right.
just a small RFE, you answer it immediately. So whenever to your point, good project, the RFE is almost like meaningless, and it's actually a good thing. It means that you didn't find anything on the source of funds. This is all
Right.
you found, so that's almost like an approval. But I agree with you 100% on the source of funds. It's interesting that you called it a game, because I agree with you. At the end of the day, maybe it's, I'm just saying this out loud here, maybe it's always a good thing to have something to go back with. Like, in other words, if you have a lot of evidence, more than necessary for it to be accepted, maybe it's a good idea to keep a couple of things with you, so that when the RFE comes, so that you can react. And some of the lawyers that I've actually done business with and who have gotten this type of thing have done that, and was actually successful. Let's move on to RIA. Everybody's in their mind, because it has really changed our business, changed our the landscape, and in many ways positive, obviously. What are the you think benefits, impact, positive, or maybe if you have some concerns that RIA brought, you think, that has made our business different? And
Well, as you know, the RIA, Marko, came out in 2022, right? And before the RIA came out, we saw before that, within those few years, many changes. The investment amount went way up, then it went way down, then it was stopped, and then
The
and
famous
then
8 days. We talked about it together. The 8 days. Yeah,
right.
it was
So
500,000. Yeah.
yeah. So Marco, with the RIA, we welcomed RIA, right? We welcomed it, and we're not going to go into what happened after the RIA was passed, where the government says, well, we're not going to renew the program until it passes Congress, and then we had a delay even after the IRA was
About
passed.
9 months. About 9 months. Yeah.
But what the RIA did, a couple of things, is that it allowed set-asides. Set-asides means that if the project was in certain geographical locations, an area of high unemployment, a rural area, an infrastructure project in a certain area, well, then that allowed foreign nationals that were in the US in another non-immigrant status to immediately apply for the green card, for their conditional green card, when they filed the 526. And it really benefited the citizens or the people that were born in India and China. So normally, if you're born in India and China, you're facing retrogression, which means that if we look at the visa bulletin, which I look at, on a monthly basis, and the unreserved category for China is 2014. That means that as of July of 2025, if you were Chinese and filed a petition in an unreserved category, that's the time that they're looking at now when the petitions were filed. For India, it's now 2019. So to avoid these retrogression, to avoid these long delays from the time you're filing the petition to the time you can apply for the green card, if you are Chinese or Indian or anyone else and investing now, and if you are in legal status in the US in a non-immigrant status, you can concurrently file your application for residency. Huge advantage, huge. Because now, even though the petition has not yet been approved, you can still apply for work authorization and permission to travel in and out of the country, include your spouse and, of course, children under 21. Huge advantage with this concurrent filing. Huge.
Right. Yes, it's a great benefit, and at the same time, we must underline that there are controls that RIA brought, whether the requirement of a fund administrator, in addition to the escrow agent, reporting requirements, all the scrutinies and everything that has brought down really the risk of fraud, the risk of non-compliance, and more often than not, the regional centers are opting to get somebody like us, broker dealer, involved,
Yeah.
so that their projects are, ironclad. Even so, have you seen some kind of a litigation trend, that has increased or that we're seeing in the marketplace, whether it is because of, delays in processing or, investors not agreeing with the, USCIS decisions or whatever? What has been your experience?
Well, most of our personal experience,
Yeah.
dealing with national investors is that ultimately the client and the investor receives their 526 approval, ultimately. But let's say the 526 is filed, they're in the US, their spouse and children also with them file their application for residency. They continue to be able to work anywhere. They continue to be able to travel in and out of the country. But let's say the 526 is filed. Let's say we haven't heard from the USCIS for over a year and a half, right? And we're thinking, wait a minute now, seeing that recently, the processing times have been quite quick, why isn't this particular petition being adjudicated or approved? So it gives us the opportunity there to file what's called a mandamus action in federal court. If we feel as though the period of time is too long, and then the judge will say to the USCIS, look, you need to make a decision. Let's make a decision in 60 days. Well, we need a little bit longer. Okay, 90 days. So by having the opportunity of going to federal court through a mandamus action, we're seeing quicker approvals on the 526s, right? Now, even though the mandamus action says we want a decision, that could be an approval, hopefully not a denial, but either an approval or an RFE, request for further evidence. So even though it may be a RFE, it's still a response from the government. And now they have their attention to this particular petition. So I think the good news is that we just don't sit back and wait for USCIS to make a decision. We've got another way of forcing them to make a decision, right?
I'm very happy that you mentioned this because a lot of our clients who have experienced this kind of thing are shy, believe it or not, of doing this. And I'm very happy to hear from a prominent immigration attorney like yourself, who basically says that there's nothing wrong with doing this. Because a lot of the clients, for the simple reason that the adjudicator also works for USCIS, they're afraid. They believe that, if we do such a thing, that maybe we're increasing the chances of getting an RFE or, God forbid, an annoyed. And I think what you're basically saying that's not necessarily the case at all. One has nothing to do with the other. In fact, maybe because they get this sort of a little push, and maybe not even a mandamus, maybe a mandamus that we're going to do a mandamus, like some kind of a notice that might actually push them. There is also some misconception out there that I think maybe it's good to clarify. Because of this concurrent filing, which applies for whether it's F1 student or H-1B worker or E-2 or anybody who has non-immigrant visa status currently temporarily in the United States, who can do this benefit. There's some rumor that out there that if you live in some foreign country, just come here with a tourist visa, and then because of the concurrent filing, you can just do an EB-5. There's obviously it's a dangerous game. That game. Maybe our viewers should understand what they can and more importantly, they shouldn't do. Because that would put the adjustment of status in real big jeopardy.
Right. And Marko, the government has always been very concerned about foreign nationals entering the US with the right intent. And basically, when we talk about coming into the US as a non-immigrant, the intent is to be a non-immigrant. Your entry into the US has to be consistent with the visa that you have in your possession, your invitation to the country. So when we talk about an immigrant intent, that means your intent is to have a green card and become a permanent resident of the US. When you have a non-immigrant visa or intent, that means you're coming in with the intent to temporarily reside in the US or visit the US and then return. If your intent as a non-immigrant now is contradicting what you may want to do in the US, then you're in trouble. So if you're in the US and you are visiting, that means that you are here as a non-immigrant. If you have a non-immigrant visa in your passport and you want to enter the US, and it may be a B2, B1 visitor visa, it may be a temporary work visa based upon your small investment in a business or intracompany transfer, right? A lot of these different types of visas, and I'll get into dual intent in a second,
Mhm.
But a lot of these non-immigrant visas, you're expressing that when you enter the US and the inspectors say, "What are you here for?" Well, I'm here to visit, as an example. And then I'm going to return to my home country. Well, then most of the time the inspectors will believe you, right? And so therefore, everything in your luggage, everything in your phone, everything indicates your entry to come in for a temporary period of time and then return. Your entry is consistent with the visa you have, a non-immigrant intent. Once you arrive in the US as a non-immigrant, and then you like it, you're visiting family, and then for whatever reason, after a certain period of time, you decide, oh, I like it. I don't want to leave my family. I don't want to leave this wonderful country. I want to stay. And in fact, I want to apply for the green card. So I'm going to go ahead and file my EB-5 investor petition. And I'm also going to file my application for residency based upon my EB-5 petition. And that means that you can concurrently file, especially if your investment is one of the investments in a rural area, TEA, or infrastructure area. So the concern that we would have as Immigration Council is that if someone is coming in as a non-immigrant and they really come in as a non-immigrant, how much time passes while they're in the US that the USCIS would accept the fact that their mind changed,
They changed their mind.
non-immigrant to an immigrant, and there's a policy that the USCIS uses, a policy or a guidance, whatever we say, that once you come in as a non-immigrant and 90 days passes, and then you say, I want to apply for the green card in the US, it's acceptable, right? If you say, well, I'm coming into the US and in 30 days I'm applying for the green card, the 30 days is probably not acceptable. But it seems like the 90 days is acceptable. Now, one of the things that one has to do as myself as the Immigration Council, and you, Marko, is that if anyone is saying, well, I want to really come in as a visitor, but I will still want to go ahead and file my EB-5 petition, I cannot start preparing documentation that says that they're preparing an immigration application for residency. I'm not going to do that. You know, if they say, oh, they want to come in as a EB-5 petitioner, fine. And they say, well, we're coming in not to adjust in the US, not to apply for the green card in the US, but we want to start the process to go through the consulate process of collecting biographical data. Sure, that's fine. That's not contradicting their entry as a non-immigrant coming in because they're going to leave and then go for residency outside the country, in another country. So any documentation, any information showing that an investor is coming in as a visitor and we can go ahead and file their 526 petition and we can collect biographical information for their consulate process, that is not contradicting their entry, coming in as a visitor and then saying, well, we're going to stay for a short period and then leave and go back, you know, after our temporary non-immigrant status. So that is okay. But it's not okay coming in as a non-immigrant when attorneys and other people and the client and investor are putting all information documentation together to apply for residency after a certain period of time once they get here. It's a contradiction. It could be fraud upon entry. They could be barred from coming into the US because of that fraud. So that cannot be a contradiction. Yeah, yes.
Very, very, very well put. And just want to underline also that many people, rightly so, together with this 526 and adjustment of status, do apply for the travel permit and the work permit. It's a benefit. Why not? We really need to emphasize not to put the adjustment of status in jeopardy, that until that travel permit comes, they shouldn't leave.
No,
right?
no.
Yeah,
No,
yeah.
no. We don't want to get too complicated, Marko, but there are a couple of non-immigrant visas that have dual intent.
Oh, that you can mention. Please do that.
Like for example, H-1B or
No
L1
problem.
transfer. so that means that if you have a non-immigrant visa, you come into the US and then all of a sudden immediately say, I want to apply for the green card through EB-5. You could do that if your non-immigrant status is L1, intra-company transfer, or H1B, professional worker. Gets a little bit, complicated, but I think that if enough time passes after you arrive, you've clearly expressed a change of mind that now you want to apply for the green card and you can.
I mean, we have cases, unfortunate cases, where the visa expires, so without the travel permit goes out, and now has basically an EB-5, petition here, adjustment of status petition filed, and now cannot get a visa, is overseas. That's why before. If the person is going to travel before the travel permit comes out, it's very well advised, I would think, to discuss with his immigration attorney.
Yeah,
Before
and if you don't have the advance parole to leave and come back, don't leave, right?
Don't leave. It's a dangerous game.
Mm-hmm.
Maybe you have some questions for me.
Yes. Well, I would say that basically, if an investor comes to us
Mm-hmm.
and they say, oh, we want to talk to different EB-5 regional center projects, right? And even if they say we want to invest in their own business, or they want to do a direct, some other separate company may have room for them to come in as a direct investor, because with direct investments, you can only have one investor per project, right?
Right.
And they come to us and we give them the immigration advice, and they say, oh, Edward, what do you think about this EB-5 Regional Center project? Is it going to be strong enough for job creation? Is it going to be strong enough for the return of our capital? We will have to say we can offer our advice from an immigration standpoint that all the documents are there to allow you to file your 526 petition. But you really need to speak to an investment advisor, broker dealer that has the ability to do the analysis and give advice on the strength of your project that you're investing in, and the fact that you can see either return of capital, or you could see an interest being made on your investment. So Marko, if someone comes to you and says, please tell us about the strength and viability of our investment, you can do so, correct?
I can. So very interesting the way you asked the question, because that happens much less than where they come in and say, we're interested in EB-5. We're working with Ed Beshara. He told us that we should be talking to you, and then we give them a whole host of different project alternatives from leading. Sponsored by leading regional centers. But it does happen where, some investors will go into the internet, believe it or not, and write EB-5 and come up with a couple of, projects. They might even have talked to the regional center on those projects, and they get biased, I would say. I mean, the regional center will obviously always tell them why their project is the best in the marketplace. And then they come to us for due diligence. We do perform that function. So in the case where an investor comes to us with a project and asks us to analyze the project, then we come up with the standard. We might have already analyzed the project anyways.
Right.
And if we have not, we will put our 50 different criteria, and explain in terms of what are the criteria, the capital structure, how much debt there is it a senior loan situation, is it a senior position situation, how much skin in the game the developer has, are they really involved financially,
right.
What kind of structure it is. There are essentially two kinds where the regional center and the developer are arm's length.
Right.
And then there is what they call vertically integrated. So they have pros and cons, and we don't take a side. Because some people will tell me that they don't want to have the regional center and the developer be different because they want to deal with one entity.
Right.
They
Right.
want to, if there's a problem, they want to go to one entity together with us, of course, with the entity and argue the case. Some will say, we don't understand this model, meaning one entity model, because we're giving them the money in terms of the NCE, and then the NCE goes and lends the money to the JCE, but the NCE and the JCE, they're both subsidiary of the same company. What's going
Yeah.
on here? So what one sees as an advantage, the other one sees as a hindrance. So we don't take it aside. We say that is why we have projects with this kind and projects of the other kind. And all we view our function here is to tell you the pros and cons of each. And then, your utility curve, your risk profile, you decide which one you go with. Same applies for rural, depending on, whether they want to go to rural or at the urban TA or infrastructure. Our job is to make sure that we open up the project in its, as many components as possible, take that PPM, distill all the information out of the PPM that is relevant, and compare the projects with one another so that the investor can make a, uh, uh, qualified decision, informed decision.
Right. And Marco, there are quite a few EB-5 regional center companies out there and projects, right? As you said, there are some that are purely EB-5 regional center structures, and they're not actually involved in the development. They're not actually involved in the management of the project. They are the ones that collect the money and then pass on the money to experienced developers, right? So that means that they're not vertically integrated, right? So do you use your experience and knowledge to explain to the investor that the EB-5 Regional Center have had a history of success? The developer, the people who are managing the actual business, have had a history of success. In other words, how strong is the EB-5 Regional Center and the new commercial enterprise? How strong is the job creating entity? And they're run by experienced developers. Do you get into advising on the experiences, the expertise, the history of success of the projects and the regional centers?
In other words, track record. So for sure, we do get involved in the track record. And for every project that we represent, we have at the bottom the 526. How many 526 has this entity, this regional center, processed?
Right.
How many have they processed this regional center for this particular developer? So what is their track record on their own if they are not vertically integrated? And how many did they do with this particular one? How many of them have been accepted? I mean, how many of them got educated positively? And if there's a gap, what is the reason? Most of the time, the reason is because they'll say that they are pending. In other words, they're already filed and they are pending. But then the number usually drops quite a bit when we come to the green card. How many of them have moved to the permanent green card status? You'll see a sharp decline, and that alarms just about every investor that we talk to. And we say, calm down. These are the reason is because many of these applications were made before the RIA. And a significant number of these investors were from retrogress countries, or maybe country, China.
Right.
So they have gotten their 526 to their dismay, because once that they got that, then if they had kids that started aging out, there was no availability for a visa.
Right.
So the green card, and then we go to the money back. How many of them have filed their 829? How many of those 829s have been approved, and how much money have they returned? So for every project that we're going to show to the client, we have these numbers, and this way the investor, the applicant can decide.
Right.
From here, what you can guess is that many projects that come to us, unfortunately, we don't take them.
No.
We don't take them when they don't, at least on the regional center side or on the developer side, can make a case. We do take cases where the developer has an enormous, an amazing track record. They just haven't done EB-5, right? But we look at their history, they've been in business since 1990, 1980, right? But this is their first EB-5. And then they team up with one of the bulge bracket, let's call them, regional centers. We're not afraid of that deal. Why should we? As long as the capital structure is good, the developer is the one who's going to use the money. And most likely they're going to pay back because they're very strong, right? The fact that they haven't done EB-5 before, that doesn't scare us.
But you're able to offer advice to an investor to say, look, not only from a business standpoint, these developers, these operators have experience and expertise, but they've also created an EB-5 strongly compliant project because the team of professionals that the developers have introduced under the regional center model, as an example, the immigration lawyers are well known, the business plan writer, the economist, the securities lawyers, the fund administrators, all these professionals that they have hired are experienced, well known, and they are behind the EB-5 Regional Center compliant project documentation.
100%. They're all in the roles that I'm telling you. We've had a fund administrator with a web link, the escrow agent with a web link, the developer. Everybody that is involved in the deal are in our spreadsheet in there, exactly to your point. So I was just going to say that the reverse is a little bit more problematic when you have a developer who is, first-time developer or not that experienced. They're, interested in tapping the EB-5 market because they heard that, the EB-5 is, cost-effective, shall we say, for a lack of better term. And then they team up with somebody, a regional center, who essentially is renting their regional center. And there are a few of those, right? They rent the regional center.
Right, exactly.
The regional center is not the one who is managing the NCE, is not the one who is collecting the money and lending it to the developer. And therefore, if there is a problem, the regional center is actually, is going to fight for the money. But it's just renting the regional center. Those deals, I think we need to be careful about.
Yeah. But just because you've got and Marko, just because you say, here's an EB-5 Regional Center project, just because one either has obtained a regional center license or one is renting a regional center license, it doesn't give any authentication and approvability to the project. You still have to do your job, Marko, in telling the investor that the project is viable. I have to do my due diligence and say to the client investor, the project is viable from an immigration standpoint. But just because it's a regional center project, it doesn't give any extra credence to the viability of the project.
Something obvious to you and me, I just want to mention it here for people who are going to be watching this, listening to this, that there is also a misunderstanding out there that an approved regional center project means that the government is saying this is, this project, right, you cannot lose a dime, which doesn't mean that. So approved, all it says is that you have a business plan. And in this business plan, you said that you're going to spend X million dollars. Let's call it $100 million. And you're going to create an edifice, a hotel, a building, whatever. All it says is that we agree that if you spend what you said you're going to spend, if you build what you said you're going to build, then the jobs that have been, are written in this business plan that will be created, will be deemed to have been created. That's it. That's all it says. So it's our job, to your point, to make sure that the building is completed. So we will go for a completion guarantee from a deep pocket, from a, there has to be somebody, that is reputable, that is giving us the assurance that building is. We're less concerned about the money as long as if there is a senior loan, it's committed. If it's EB-5, we have conviction that EB-5 will be raised, and then the equity is there. So as long as there is the money there, then we have less worry that the money won't be spent. Because if anything, in construction, as if anything, the expenditure is underestimated. So that's not a major risk that they're going to spend less money. They're probably going to spend the same money, if not more money, but they might not be able to finish. And if they don't finish, the jobs will not be created. So, and the other misnomer is that some people, again, it's not their business, so they don't know. They believe that this is government guaranteed. This EB-5 that you do, Marko, it's government approved. We're giving the money to the government, right? No, it's not government. This is a private enterprise, and there is on debt. The reason of existence of a company like us is to make sure that you're giving the money to the right people.
Yeah, and Marko, do you, like we do, and I know that you do, we also have to advise the client that some of the first steps in getting the conditional green card, they have it for 2 years. And then at the end of the 2 years of permanent residency, they have to file a petition, an 829 petition, to remove the conditions. So there's documents that are needed from the project, right, that are needed to show the investment was sustained, right, either in the JCE, or if it was returned to the NCE, it could have been redeployed in a investment at risk, and also the jobs were created. So do you continue to be involved and advise the investors about not only themselves getting their conditional green card and the project being viable, but the advice that you give the investors on the viability of the project, that in a couple of years they're going to comply, usually because of their track record, with supplying the right information and documentation for the investors' 829 petition to remove the conditions? In other words, proof that the project did not let the investment funds back to the investor too early. We, representing the investor client on the 829 preparation, showing through their tax returns, then they never received any money back too early. So are you involved at the 829 stage as well?
Until the 829, and most of the time after the 829, we're always in touch with the investor, and we're always in touch with the regional centers, who are giving periodic developments on the project. On the accounting side, the K1s. And, investors, until they get their money back, until they get their permanent residency, and many of them until they get their citizenship, they're always, reaching out to us, and we're giving them, support.
Now, what if the project doesn't do well because of COVID? There could be, for example, some hotel projects, and the hotels have done not well, and then the developers trying to sell the hotels. Do the investors, in your opinion, and I've got an answer, of course, but in your opinion, the investors, even if they don't see a return of their capital, they can still go ahead and file the 829 petition showing the investment was sustained and jobs were created, and still get the full green card, correct?
Yes. Yes. I mean, there can be a misconception that if the project is defunct, or if the project goes under, that is going to spoil the entire immigration benefit. That's not true. The immigration benefit has to do with job creation, and the capital payment is the financial risk. So as long as they took the financial risk, I would say that that is a proof that they took the financial risk. Because the law says that the money has to be at risk. Me, man, my money was at risk. Listen, I lost it. So there is no bigger proof that the money was at risk than losing it. God forbid. I mean, we're not
Sure.
showing projects like that, but just as a joke. Like in other words, if a person doesn't believe you that their actually immigration benefit is fine, you just show them the law. But on the other hand, the jobs have to be created. So in other words, if he gives the money and then the money goes to fraud, I mean, that goes without saying that there's no immigration benefit. And even if it doesn't go to fraud, but in the early stages of the project, somehow, the jobs, in other words, jobs kind of created. If that happens, then I would say, then he loses both.
So what would be your last word, Marko, in being able to advise the investors? The investors come to a conclusion that they want to get a permanent residency in the US. And what about those investors that have friends or business people in their own country, and then those business people are trying to get those friends or investors to a EB-5 project? Can those friends really advise the investor, or do they need to definitely bring you in to advise the investor, even though they may have a friend referring the investor to the project?
But it goes without saying that they do, because it doesn't mean that even if, let's say, we work with an investor, we put them in a project, it doesn't mean that the same operator, whether the regional center or the developer, when they come on another project, that it will have the same strength.
Mm-hmm.
I'll give you just one example. For example, a regional center that we do quite a bit of business has repeatedly provided a guarantee on the NCE loan to the JCE. Very rare. It's a very rare thing. The law says that the money has to be at risk, meaning that the investor's money cannot be guaranteed. So therefore, most regional centers will show you that and say, because of that, we cannot put any guarantee. But we know, and I know that in the early stages, early years of EB-5, this was very common. Now it hasn't been common anymore. I'm just giving that as an example, just as an example, where the loan that with the pooled EB-5 money that the NCE has, that loan that NCE is making to the JCE, there's no law against it being guaranteed. So no. I give that example because you could have a client, who invested in a project with that feature, and then, a year later, he tells his friend, "Hey, don't have to call Marko. Just call the regional center directly." And then it's very possible that the investment that they're going to make doesn't have that feature. I'm just giving that feature. I'm not saying that you have to have that feature. I'm just saying that one deal doesn't have to look like the other deal. Every deal is a separate deal. Another case could be that we put the investor in a deal because we really like the equity. The equity, in other words, the skin in the game. We saw that the developer at 50%, 60%, 80%. I mean, you could have deals where the equity is so strong that it's just very difficult for them to lose money, plus the job creation, all that. But I'm talking about just as a capital structure. There's no guarantee that the next deal or the deal after is going to be like that. So 100%, just like I would never tell a client to file their 526E on their own. I will tell them, call Ed, call the immigration attorney. You'd be crazy to do your source of funds and file. I think the same goes for this. But one advice, if you're asking me, that we give to people who actually do work with us, aside from the fact that they should work with us and you and all the market professionals, do not rush. I think if I were to give one advice, I would tell the investor no matter how much incentive you have to rush, do not rush. There will always be good projects out there. Just because you fell in love with a EB-5 project and you are dying to get into that project, don't, overwork your immigration attorney on the source of funds and just basically, tell him just finish it off. No, because the source of funds is the key in EB-5, and if it's not done, uh, you know, if it's not done properly, then you're almost like putting yourself in danger to be denied. So don't process your EB-5 until you get a clear go-ahead from an immigration attorney on the source of funds. And then as long as you're investing in a reasonable project, I think you have nothing to worry.
Yeah, and if an investor says, Marco, and they say to me as well, look, with the new law, RIA, it seems to allow a process of investing, which is wonderful, because if the investor says, look, I've got in the US right now $200,000, I have liquid assets that I can liquidate, but over the next several months, which I'm going to do, I can then put the balance of what's required to the other 600,000 over the next several months. So do you think today this is an advantage, the process of investing, that the investor can do a deposit and then start the EB-5 526 process?
The answer that I give to my clients is yes and no. A very political answer. So yes, if they already have the assets and it's illiquid. In other words, they have a stock, portfolio that
Right.
they're just not ready to sell for whatever reason. I don't really care, whether it's they think the capital gains tax is going to be too high. Like for example, I'll tell you to Turkish investors, if they have a capital, whether it's real estate or stocks, anything, and they hold it for 5 years, then there is no capital gains tax, right? So if they only held it for 4.5 years or 4 years or whatever it is, 4 years and 3 months, and if they sell it 9 months after they invested, now they're not going to be paying any capital gains tax. By all means, you want to, but where we say that you're in dangerous territory is when they say, I only have $200,000 now, but I will have the other 600,000. I go, how? Where?
Yeah.
I'll get it. Well, no. The source of funds is so, they have to be able to show where the money, if the money is locked up, okay, because it's going to be sold. But if the money is not available and they're just wishing, that it's going to come, I think it's a dangerous territory.
Right. Other countries, Marco, and I know we're running out of time, but other countries show that as an investor, you can invest in another country in real estate. And as a result of investing in real estate, you can get citizenship or residency in that other country. Now, in the US, in the past, we would tout as immigration lawyers, and I'm sure you would say that if you buy real estate in the United States, that is not a way of getting residency, immigration residency in the US. But it could be a way that we would say to the foreign national investor, protecting your wealth, because remember, investing in EB-5 is at risk, right? Protecting your wealth, you can take your money, buy US real estate. It could be townhomes, it could be townhomes that are rented out, but you can pay cash for real estate, as an example. Then go to a mortgage company, get the mortgage money, and put that in as the EB-5 investment, which has to be 100% at risk. But your money worked for you initially in buying, let's say, a number of townhomes. There are management companies that can rent out those townhomes, so money's coming in. And now you've used your investment in real estate as a way of protecting your wealth and as a foundation of getting the money needed for EB-5. Do you ever have these discussions with your investors? I do, but do you, Marco?
Yes, I do. And in my case, it comes about when the concern is on purchasing power of the money. They basically say that we're okay with the fact that the EB-5 really doesn't return as much, maybe 1%, 2%,
Right,
whatever.
right.
But what we're really concerned about is, when the money is going to come back in 4 years, 5 years, 6 years, the purchasing power of the money is going to be really low. So
Okay.
for those investors, we tell them exactly what you just described.
Okay.
That with the money that you have, you can buy real estate, and because you being in cash for that, and then you can do a mortgage against it. And if you were to rent the real estate with the money, the rental income, you can pay the mortgage interest, you can pay the common
Right.
charges, the taxes, and maybe sometimes you can even have money left over. What we do see also, I thought you were going to explain that, the differential between the US system and the European system, where if the project is not finished, meaning if the condo is not finished, Malta won't give you citizenship, residency. Yeah, Spain, Portugal, England, UK, all of these programs, they want the jobs to have been created, and invest in a job created situation. Our situation here is just the reverse, and that takes time to explain people. We say, from the United States standpoint, once the jobs are created, what are your money doing? Because here the whole idea is we want to create jobs with the money that you're giving it. But the formula that you suggested really blends it, because now you are actually buying a finished product, but then by mortgaging the finished product, you can also get the EB-5 benefit.
Right,
It's
right.
perfect.
Exactly. Marko, what is the last word? What's one word you can state to say to people what they should be doing? If you could say it, and I'll say it as well, but go ahead.
No, I said it. I thought I said the don't rush business. EB-5 is a wonderful program. I mean, I would
Yeah.
say that it's a wonderful program. It's something that doesn't fit everybody, but for people that it does fit, I think it would be a disservice,
Right.
by the professionals, whether it's me or you or anybody else, not to give this as an alternative, because not everybody can do EB-1. Not everybody is at the top of the game, internationally known and everything else. I mean, if he is, fine, give him an EB-1, but not everybody is in that category. So I think EB-5 is a wonderful program for people who have the wherewithal, especially parents. One word for parents who spend at least $300,000 or more, for a bachelor degree. It would be the best gift you can give your child, to be able to allow them to put that amazing American education that they get in here from these universities, to put it into the practice. And for that, they need a green card, and EB-5 would be one of the best ways to get that accomplished.
Right. Well, I would say that, I like practicing in the EB-5 space. My initials, Edward Beshara, my initials are EB. My birthday is going to be on Saturday, the 5th,
Okay.
so EB-5. And as you know, Marko, the number of our office building is 555.
Very nice.
So
Very
I
well
do
put.
like
Yeah.
EB-5. But the last word, I'd say the last word in self-help is help. The last word in self-help is help. In other words, for the foreign national investor, don't think that you can do this yourself. Don't think that it's okay because I'm experienced in the business world. Don't think that you can self-help. The last word in self-help is help. Get the help of Marko, of Edward. I'm the immigration counsel. Marko is a broker-dealer, investment advisor. So get the help of people that are experienced in this field.
Ed, this was wonderful. I'm so feel privileged that you gave us, over an hour here of your time, which I know is not that it's very precious. Thank you very much. I am sure and I'm confident that our viewers are going to enjoy and learn a lot from this session. Thank you.
Well, thank you, Marko, for your help and assistance and wonderful presentation, Marko. Thank you again.
Thank you.